Welcome to A Lawyer's Guide to the Galaxy, a podcast about geek culture by lawyers with your hosts, Ben Siders and Kirk Taman.
And welcome back to A Lawyer's Guide to the Galaxy, the podcast that asks interesting questions that don't have any answers with your host, Ben Siders. That's me. And the other guy is Kirk Damon.
That's Kirk, as in the captain of the Enterprise.
We are intellectual property geeks and certified, or no, other way around. We are intellectual property geeks, but we are intellectual property lawyers and certified geeks. We are not, well, I guess we are certified intellectual property lawyers too, because we're registered to practice for the patent office. You know this shtick. We're a bunch of dorks doing law in St. Louis. And so we're going to talk about some law today. We originally were going to talk today about, there was a case that came down last year involving the Fortnite dance lawsuits. Those actually never went away. There were more of them. And we got an interesting appellate holding that explained a little bit about how choreography copyright works, which we thought was interesting because, one, it almost never comes up. So it'd be fun to talk about. But something else happened that's more urgent. As of yesterday morning, we're recording this on May 10th of 2024. As of yesterday morning, the Supreme Court issued a decision in a case called Warner Chappell versus Neely, a copyright infringement case, which, if you listen to the news reports, seemingly rewrites the entire copyright statute to allow copyright owners to get infinity damages going back to the beginning of time.
Yeah, exactly.
The reality is a little less salacious and a little less interesting, but
we think it's interesting.
We think it's interesting, but we want to talk about that for a couple of reasons. One, we do have a lot of lawyers who follow the podcast. Many of you are IP lawyers. Some of you are not. But you have probably seen this, and you're probably wondering what exactly it means and how much you can rely upon the reporting you've seen on it. And for those of you who aren't lawyers, you may be justifiably concerned that the fan fiction you published in 1994 on your GeoCities page could now get you in trouble. So we're here to put your mind at rest.
Well, maybe.
Yeah,
and that's, I think the big thing behind this is it's, we do these kind of episodes with it. We find that, people are very interested in them, either because they're looking for our take, because they are lawyers, already have their own, and just want to hear what we have to say, or for people who don't really understand what sort of happened, or just interested in what we have to say about it. From that point of view, I think we're going to start this off pretty simple. For those of you who are lawyers, you may be able to skip about 15 minutes, but...
Yeah, unfortunately, we kind of have to lay some groundwork here because this case presents an interaction of a bunch of really weird concepts that even amongst lawyers are easy to get mixed up. It's mostly about the statute of limitations, which, if you don't know what that is, it's effectively a legal rule that says after a certain amount of time, if you haven't filed a lawsuit about something, you can't.
Yeah, and the point of the statute of limitations, and I think what to keep in mind, a lot of people look at it and say, but isn't that kind of unfair? If something, if I had something happen to me, why can't I bring it when I want to bring it? And the idea behind it basically is it's sort of twofold. One of which is, look, if you bring a case too late, memories fade, evidence gets destroyed. So we don't want to make it that you can say, well, let's hold off for 30 years so nobody remembers what happens.
Then we're going to file a lawsuit. Yeah.
So we have to look at it and say, look, do it quickly if you're going to do it. The other reason for it is it's if you've been wronged, and the purpose of a lawsuit is basically to try to say, hey, you've been wronged. You need some kind of restitution, some kind of resolution, really, to this issue. You need it. You should need it quickly. If it's not important to you to get it now, why should it be important to you to get it in the future?
There's a legal Latin phrase that I'm going to butcher because I just now remembered it, but it's something along the lines of justice rewards the diligent or something like that. Like if you've got a cause of action, if you've got a dispute with somebody, the purpose of the law is to resolve disputes. And sometimes the resolution is that we're just not going to do anything about it.
Yeah, we won't resolve it.
I mean, think about it. Most of your disputes with people obviously never go to court. I'm guessing that the majority of you have never had a legal case outside of maybe like family law or something like that, or like an estate adjudication. But in terms of like a genuine, personal or commercial dispute, we don't resolve these things in court usually. Usually the stakes aren't high enough, and we just let things go.
Yeah,
is the bottom line. The law is not here to resolve every last little thing, and the way most things get resolved is people just work it out informally, or they just drop it. And the idea is, at some point, a claim is so old that if you haven't asserted it yet, one of two things is probably true. Either it's not important enough for it to be worth your time, in which case, fine, we're going to say you're never going to assert it, so it's not some sword of Damocles hanging over the head of the other person, or vice versa, if somebody's got a beef with you. Or two, you've just waited too long, and at that point, we're just going to say, then tough. You can't just sit on your rights forever. We have to have certainty so people can move on with their lives and move on with their businesses.
And I think the real thing to keep in mind in this is keep in mind, in many respects, the purpose of the legal system is to resolve disputes. It doesn't mean that the resolution is fair, desirable, or what either party wants. It means that it is resolved. And that's where a lot of people kind of look at statute of limitations and say, but isn't that unfair? And the answer to it is...
Can be.
Yeah, it can be, but it's also resolution. It is definitive resolution that says... sort it out on your own, because we're not going to step in. You have no right to come to us and ask us to resolve it, because you didn't in the time you were supposed to.
So the statute of limitations, let's start with something simple. It's easy to understand, because it's actually, for such a simple concept, it can be difficult to apply and practice, like everything else with the law.
And another reason also to refer to, it's usually referred to statute of limitations because it's usually in the statute which defines what the thing is. So it usually says there is a window in which this has to be brought.
Yes, absolutely. And there are common law causes of action where if the legislature has not stepped in and imposed a statute of limitation, then there is none. That does happen from time to time. Let's talk about something simple like a tort. Torts are accidents, personal injury, things like that. Imagine you're at, say, a store, like a big box store, and there's a leaking pipe and there's a puddle of water that builds up and you don't see it because it's kind of dark in that corner. You slip and fall and break your ankle. Yeah. Okay. So it's possible. Basically, you have a claim for negligence against the store. It may or may not be valid. The store may not have been negligent, but you certainly at least have a claim for negligence.
You have been injured, and you were injured presumably by an action or inaction of theirs because you're in their store. So you have a possible claim for a tort.
Yeah. And then they've got insurance. The insurance company's going to step in and defend it. They're going to pay you to make you go away, and that's how that's going to get resolved. So, but the bottom line is you have a claim, and under the law, you have a certain amount of time to file that claim. Torts are usually between 3 and 5, maybe 7 years, sometimes longer, at least for a tort like this, for personal injury that's readily discernible. Yeah. I think in Missouri it's 5 years for tort.
And it's from the date of the injury, the time of the injury.
You know when you're injured. So as of that date, you start counting out the 5 years. So the question is, well, what happens if, I break my ankle, I go to the doctor, he sets the bone, and then 15 years later, I'm going to ice skate, and my ankle is just killing me, and it hurts and it's sore, and I go back and I have it x-rayed, and that bone that broke is now all growing weird. It's got strange, bunch of complications 15 years later. Can I go back and go after them now? And the answer is no.
Yeah.
Believe me, I know, because I'm telling an autobiographical story. This happened to me.
And the real key behind it is that you had the injury. These things grew out of the injury. Now, because you have a second cause of action that is accrued against somebody else, for instance, if the bone was set wrong, you may have something against the doctor. If it's a later injury a later action which then caused the re-inflammation of another injury, that could be a cause of action. So if you fell at another store and re-broke the ankle because it was weakened in the first injury, that could still be a second, cause of action. So it's not like we're saying, hey, this is, but if we just say simply, hey, yes, everything was done correctly to resolve the injury and it just didn't resolve.
That's just my bad luck.
That's kind of your bad luck.
Yeah. So that's how that happens. This is what we call the injury rule. We start counting up the statute of limitations from when the effects of the injury were felt or when they happened or when they were otherwise readily discernible. With a personal injury like that, when your ankle is broken, or at least when it hurts. Yeah. So that one's pretty easy. It can get messy, though. Toxic tort is a situation where you may not know you're being bombarded with invisible radiation that's slowly poisoning and killing you until 20 years later. Yep. So in cases like that, there's no way to discern the injury, no matter how careful you're being. And so we sometimes have something called the discovery rule, where once you discover the injury, then we start measuring when the statute of limitations begins to run. There's also a related concept called equitable tolling, which is where under certain circumstances, we're going to toll the statute of limitations, meaning it's going to pause temporarily. It will resume at some point. And that concept is often applied where somebody has engaged in fraud or concealment or taken some action to make it difficult for you to tell that somebody is injuring you or otherwise violating your rights.
Yeah, so the idea behind that, and I think the real key behind it is this is usually somebody sort of knows they're injuring you or has reason to believe they may be injuring you, and they're essentially purposefully covering it up.
Yes.
So they're making it that you can't figure out that they have injured you.
Often, maybe even for the purposes of running out the statute of limitations, the courts are going to say, no, the law is not that dumb. You can't just
exactly. Yeah, and so, but the key about that is that it really is, there's a really active fraud or concealment component associated with that, which is really saying, no, it's not just the fact that you hadn't discovered the injury yet. You may have even discovered it, but you had no possible way of knowing that this person caused it because that was purposefully concealed from you.
Yeah.
By that person.
Outside of those situations, toxic tort is a big one, and fraud and concealment. Most areas of law generally will use this injury rule.
Well, even toxic tort in many respects, in some sense, it's still the injury. It's just that in order to reach the level that the injury is learnable as an injury, it has to have been occurring for a number of years, or it has to have been a certain number of years in the past. there's still a very clear connection to it being an injury and that you find out you have an injury. It's just we look at a lot of injuries like breaking your ankle and you know immediately that you've broken your ankle or very shortly thereafter that you've broken your ankle. But again, if you're being slowly poisoned, you don't necessarily realize that until it reaches a certain level.
Yeah.
And so the idea is that the injury kind of occurs later. So when do you figure out you're actually injured?
And sometimes it's easy to deal with if the injury is still being applied. If there's somebody's poisoning your water supply and you're still drinking it, okay, well, every day I'm being injured again, so my claims are always ripe to file. What happens when you grew up in a house as a kid that had a bunch of leaded gasoline poured on the yard or leaded paint or something, and you've since moved away and you've been gone for 20 years?
Yeah.
You know? So at that point, the injury has been felt, it's gone, and you didn't know. So this is where these fact patterns come from.
Yeah, and again, the real behind this as we sort of look at it is, and you can see sort of in those two exceptions, the injury rule makes sense. But when you look at the idea and sort of look at the other two and say, look, here are the fact patterns behind these, you can kind of look at it and say, it's still the injury rule. It's just something happened where we kind of looked at it and went, yeah, but we had no way of knowing it was the injury rule at the time the injury occurred.
So we're going to wait till you discover the injury.
And we don't want people to get out of it just because they did something that's hard to figure out.
Yes.
So
turning to the case that came down yesterday, how does this work in copyright? Well, the complication in copyright is that although the injury rule is not normally used in commercial law, the injury rule is normally used in commercial law, the discovery rule usually is not. Copyright is not one of those areas. All of the circuit courts, as far as we know, I haven't found one that is contrary, all of the circuit courts use the discovery rule in copyright cases. And the discovery rule says that your claims accrue, meaning that you have your cause of action and therefore the statute of limitations begins to run once you either discover the infringement or, and this is important, with due diligence, should have discovered the infringement.
Yep. And so, the real key here is that copyright's a little unique in the fact that we have this. It's still effectively the same injury rule as what it is. You have to have the injury occurs. Like a sort of poisoning type scenario, you also got to keep in mind copyright infringement can keep occurring because a copyright infringement occurs with every copy. So it's something where somebody could be copying a work, making repeated copies, one a day. For an example, they're making one copy, selling one copy a day. Every day they're committing a new injury and a new form of copyright infringement, sort of like the slow poisoning scenario. When you find out about those, it starts accruing from which one you found out about, from it. So if you figured out, they've been doing it for a year, you figured out a year later that on the first one they did it. Yeah, you've got an injury, you can cover the next ones, but the question is, can you cover the old ones? Well, yeah, so long as you found out within the statute of limitations, you can file with the statute of limitations saying the first one actually was an infringement. I'm entitled to say that it's still within my own statute.
Yeah, the way it typically works is that each individual infringement is a separate action. So let's just say somebody stole some music you wrote, and they sold it to a music company that's been played on the radio for the last 20 years.
Yeah.
And then let's say you knew about it the whole time. All right. So on day one, in 2024? So in 2004, they played your song on the radio.
Yeah.
And you heard it, you're like, hey, that's my song. You have a cause of action as of that day. And if you don't assert it within 3 years, you can never assert it. And then the next day, they play it again. That one accrues that day. If you don't insert it within 3 years, it expires, and so on and so forth. So when you actually do get around to filing your lawsuit, the only things you can file for are the infringements within the last 3 years because you knew about the rest and you didn't do anything and they're all expired. So the practical effect of this rule in most cases is that you can only get damages, you can only get paid for the last 3 years of infringement because the claims that would have happened before those last three, we should say the copyright infringement statute of limitation is 3 years. That's why we keep saying that. The claims from before that you knew about, didn't do anything, they've expired. So practically speaking, usually the statute of limitations is also the only time period you can get damages for.
Yep. And this matters because, as you sort of said, in copyright's a little bit unique because each individual act of copying is potentially
each display,
separate.
Each broadcast, each sale.
It's a separate infringement. So we say, hey, if the song is played every day on the radio since 2004, you can still get 3 years worth of damages because you've been played every day since 2004, which means since 2021, it has also been played every day.
Yeah.
So you have 3 years worth of playing to go forward back with. Now, you can't get the one for 2004, but you can get the one for 2023. That's sort of the way of looking at it. And again, people sometimes look at that a little weird. They're like, but aren't they both infringement? Aren't I being damaged for both? Yes, but when you say the fact that the damages accrue for an individual infringement, you're only getting paid for the one which occurred in 2023, not the one that occurred in 2004. Why it matters is if it's no longer played on the radio, it was played on the radio incessantly in 2004 and is now no longer played.
Let's say they stopped in 2010.
There is now no longer anything within 3 years that I can say is within the window. So I can't bring the copyrighted suit because there's been no infringement within the last 3 years, which also means I can't get any damages because I can't even bring the suit.
Yeah, there's no infringements that you can timely file for. Nothing's happened in the last 3 years. So
yeah, that's the sort of real key behind that. And the way to be thinking about it is kind of, it's this ongoing infringement idea. And again, that's why I'm kind of pointing it to the idea of like the poisoning. If you're being poisoned every day, you have an injury of being poisoned tomorrow, but you also have an injury being poisoned 3 years ago.
And all of it.
And the discovery rule kind of says, but you also get to go back to when you first started being poisoned if you just figured it out today.
And this is where it gets freaky with the Copyright Act, because the Supreme Court's holding yesterday, you're going to see it reported as the court says that you can get copyright damages forever for everything, no matter how far back. That is true, but only under a limited set of circumstances, because the Copyright Act doesn't say anywhere in the text how far back you can go for damages. It just says whatever claims you've asserted, you can get damages for. Now, practically speaking, since you can normally only assert claims in the last 3 years, you can also normally only get damages for the last 3 years. But if you can find a way to assert claims for infringements that happened more than 3 years ago, prior to the statutory limitations period, the Copyright Act says you can get damages for those too.
Well, the Copyright doesn't say. I think that's the key. The Copyright doesn't say.
It doesn't specifically address the issue. It just says you get damages, and it doesn't say you only get damages in the last 3 years. So the courts are going to assume, okay, that means you get damages for whenever. So this issue kind of came up about 10 years ago in a case called Petrella. And that was sort of the typical case we talked about. The plaintiff owned the rights to the screenplay to, it was Raging Bull, I think, right? Raging Bull screenplay. And claimed that the MGM that was producing the film didn't have the rights to it anymore. And she knew this was going on for a long time, maybe a decade or more. And she'd sent letters, made demands, and nothing had happened. MGM kept making and selling copies of the film, and she did not assert her rights. Until one day she did. But she only sought damages for the prior 3 years because she knew all along that this was happening. She had discovered them all. And so the older claims had accrued and expired and were untimely and could not be asserted.
And I think some of this also had to do, if I remember right, the damages also wasn't because there was theatrical releases, there was DVD releases, there was video releases.
Yeah.
So you have ongoing releases going on during this time in different formats and different things.
The reason she didn't file is because the film was unprofitable, and one of the measures of damages is profit. So she was waiting until there's actually some profits. If the film never turned a profit again, well, then there's no reason to ever file a lawsuit. That's a feature, not a bug.
Yeah.
So she waited until it was profitable, then filed. MGM said, well, that's not fair. You can't just wait until we make money and then come after us, to which the Supreme Court said, why not? It seems like that's the best time. I mean, well, why would you file when there's no damages? So if you didn't want that to happen, you should have settled this out when there was no damages and it was worth less. So MGM had tried to argue something called latches, which is that you've waited too long and now you can't pursue any of your claims in the last 3 years or not. The court said, no, that doesn't apply. The 3-year statute of limitations is protection enough. She only gets damages for the last 3 years because those other claims are untimely. Fast forward to today. And the case that came down
Let's start with that, just to sort of say a little bit from Petrella. The real key about this is we have infringement that occurred more than 3 years ago. We have infringement which occurred within 3 years ago. What we have the Supreme Court saying in Petrella is you can bring the suit because infringement occurred within the last 3 years, and you can get damages on the infringements that occurred within 3 years because that's what you asserted. So we have that kind of meshing of the 2 3-year windows. But the key fact to keep in mind, there is infringement before 3 years. It's just those were untimely sued because she couldn't bring it.
She can't get damages for those, not because the Copyright Act says she can't, but because it says she can't assert those claims at all. They're too old.
Yep. And so that's the thing, is it's those happened, but there's no lawsuit at all saying I'm entitled to damages. But the court says, yes, you can bring the suit because there's something within 3 years, and you are entitled to damages for 3 years. They don't say you're entitled to damages for the window of the suit you brought. You're entitled to damages for 3 years.
So, fast forwarding to what happened in the case that came down yesterday, the facts are a little bit different, and they're kind of complicated, so we're going to condense them. The plaintiff is a guy named Sherman Neely, and he established a music company in the 1980s called Music Specialist, and they recorded and released an album and some singles in the 80s. But Mr. Neely had some expensive hobbies that landed him in prison. Chiefly drug use and distribution. He went to prison until 2008, after which he was released. The facts are a little muddled after this. Some of the sort of explanations of the facts I've seen indicate that he might have found out at that time that his music was being used by somebody else.
It was Beck's business partner who founded a
ex-business partner, yeah, who was using the music with Warner Chappell and a couple of other labels. But at any rate, Neely went back to prison again in 2012, got out in 2015, and he definitely found out in 2016 that his music had been sampled by Flo Rida, Black Eyed Peas, a couple other people. Some of these songs had sold millions, and so he filed a lawsuit against the labels within 3 years of finding that out, saying, hey, you've been using my stuff. Lawsuit, by all accounts, we have to assume at this point the case has not been resolved yet. But when you are at the early stages of pleadings, we just assume everything the plaintiff says is true for purposes of motions to dismiss and things like that. So Neely said, well, I filed in 2018. I learned about it in 2016. 18 minus 16 is 2. I'm on time.
I can file inside my 3 years. Yep.
And nobody, I think, is disputing that.
And this is a discovery rule, essentially, of asserting I found out about none of this prior infringement until 2016. There is, and it's sort of Ben hinted at earlier, there's some weird facts around 2008. If you guys are big into the case, you can get into sort of what happened with this. For the purposes of this discussion and what the Supreme Court was looking at, all of that was sort of assumed to be resolved in the plaintiff's favor, which means it doesn't hurt them at all.
We're assuming he didn't really find out until 2016. You have to assume that as a fact. It may not ultimately prove to be true, separate issue. So under the discovery rule, the case is timely filed, and Neely sought damages for all of the infringements, which went back to 2008, to which Warner said, well, now, wait a minute, time out. You only get the last 3 years of damages. That Petrella case that we just talked about, it says so. Also complicating this, the Second Circuit, now this case is in Florida, so we're in the 11th Circuit. Mm-hmm. The Second Circuit, which is a very important circuit for copyright because it has New York in it, a big city with lots of copyright-based industries. The Second Circuit had already held, after Petrella, that what that decision means is that you only get damages for the prior 3 years, even under the discovery rule. So that was Warner Chappell's argument to the 11th Circuit. You need to follow what the Second Circuit has done, even though other circuits like the 9th, California, had said otherwise. So we've got what we call a circuit split. We have one federal law that's supposed to be the same everywhere, but it's working differently in different places.
And that's why I kind of pounced on that statement of Petrella, where they didn't say they're linked because of the statute of limitations. They said you get damages for 3 years. The Second Circuit said, we take that to mean 3 years, regardless of how long or when the act occurs, you're still limited to damages by 3 years. So it basically separated the window in which you get damages and the window the act had to occur in for bringing the suit to now being able to be different. You could bring the suit for something which occurred more than 3 years ago under the discovery rule, but you can only get damages for what occurred within 3 years. That's kind of what the Second Circuit says in this, and basically splits the two pieces apart. So and again, that grows out of Petrella, it grows out of a Supreme Court case that says, in that case, yes, you can only bring the suit for the 3 years. There's infringements which occur beforehand, and she can only get damages for 3 years because that's all she can bring the suit on. But they say 3 years. They don't say essentially that because that's all she can bring the suit on is kind of left implied.
Yes. And what's interesting to me about Neely's situation, so he's in prison. So, obviously, it's not hard to understand why he would not actually know what has gone on. But there's still that with due diligence should have known. And, and this has not been figured out in the case yet. These facts have not been explored. But just intuitively, my first thought is, okay, well, is it, I've never been to prison, so I don't know, but are you really that cut off to where you wouldn't even know that these songs are on the radio and that they're using your stuff? It's entirely possible. But, they have TVs in prison. They have radios in prison. So there is a fact question about whether with due diligence, Neely should have known about those infringements. But again, we're assuming for purposes of the case that he didn't and that he couldn't.
Yeah, and that's a real key thing about the Supreme Court case is there's a lot of things that the Supreme Court in this case going up, you assume about the facts of the case. They may or may not be true. They have not been resolved. But for the purposes of doing this, they were basically coming to the question of assuming that there is this case that he found out in 2016, he filed in 2018, so he's inside his 3 years under the discovery rule. The infringements occurred prior to 2016. At least a lot of them did, and I believe the understanding with it is
I think the majority
a lot
of them,
the sales,
possibly all,
occurred prior to 2016. I think it may even be all of them. Yeah, I think you're right.
Just as Gorsuch suggests, maybe all of them are.
And so everything's in front of him. Can he get damages for that? Vast majority, if not all, of the acts which occurred, but are outside this 3 years, given that he did correctly file within 3 years of when he discovered it. And if not, well, by the time he discovered it, he kind of loses his right to collect anything, right? Isn't that bad? I mean, you kind of look at it and say, isn't that unfair that it took him this long to discover it, particularly being in prison, and now he can't get anything? Is that really right? And so that's kind of the question that goes up to the Supreme Court. And I think the next thing that I can see Ben, being interested in wanting to get into this is what goes to the Supreme Court in this case.
This is critical because if you're being very careful and thoughtful about this, you're thinking, how in the world are these facts already known? The Supreme Court is a court of appellate review. Shouldn't the case be over and the judgment be appealed? We should have figured all this out already.
Yep.
And the answer is,
no,
not in this case, because Neely and Warner Chappell disagreed on this point, and Neely said, well, look, if I'm wrong and I can't get damages going back more than 3 years, this case is not economical to pursue. I'm just going to drop it.
Yeah.
And Warner Chappell, of course, probably said, that's a great idea. Let's figure that out before we spend a bunch of money litigating this and working it out. And there is a procedure called interlocutory appeal. Normally in courts, you have to get to a final judgment, resolve all of this, preserve any legal issues, and then appeal. However, there are procedures to appeal a pure issue of law that is critical to the case, without which the trial doesn't make a whole lot of sense to do, called interlocutory appeal. Here, the district court, the trial court, said, yes, this is one of those. Let's send it to the 11th Circuit and ask them what they think. Actually, I think what happened originally is they had a motion for summary judgment on this. The district court said no more than 3 years, and they certified the question on review to the 11th Circuit.
Yep.
They reversed and said, wrong, you can go back more than the 3 years. And then Warner said, okay, well, sir, I object. And then they went to the Supreme Court and said, you got to answer this before we do this trial. So that's how it got to the Supreme Court without any of these factual issues being resolved. It could eliminate all of this.
The real key thing to think about this, for those of you who may not be lawyers and aren't used to the term interlocutory appeal, the idea behind interlocutory appeal is basically we have a question of what the rule is, which effectively, whichever rule is right, is going to decide everything else.
Yes.
At least if it's decided one way, it decides everything else. And so what these courts do is the district court looked at it and said, we have that scenario here, so I'm going to issue a judgment which says this is my interpretation of how that rule works. And the court basically says, look, the parties say, look, we need that resolved, because if it resolves in favor of, in this case, it resolves in favor of Warner Chappell, Neely's done. He's not going any further because there's no point in continuing this case. Now, if it resolves in the impact of Neely, the case is going to continue. We're going to have to work out the other facts, everything else. But there's no real point in figuring out what may have happened in 2008 if what happened in 2008 is completely moot to determining anything else later on.
Neely's basically saying, I don't even want to spend the money to work that out if I can't get damages going back, because it's just not worth my time.
I don't care.
And of course, the court's like, great, sounds good to us.
And so, the idea behind this is let's save money, let's go ahead and send it, because this is a question, we need to know the answer to it. So they send it to the 11th Circuit, and the 11th Circuit says, okay, on that question, underneath this discovery rule, we only thing we're looking at is basically are damages limited to 3 years.
Of law. Can you look back further than 3 years? They agree with the majority of circuits right now that say yes, you can. The only one that says otherwise is the Second Circuit. They said, with respect, Second Circuit, we disagree. And they went to the Supreme Court to figure out who's right, the Second Circuit or everybody else.
And basically, based on Petrella, they're both based on the same case, so that's why you have the circuit split. The other thing with it, we say question of law, what that means, you always hear in law school, there's questions of fact, questions of law. Questions of law are literally just the statement of, if we agree as to exactly what happened, so the facts are entirely in agreement as to what it is, we don't know what the outcome is by the law of that. That's a question of law. A question of fact is what actually happened.
And the Supreme Court, in cases like this, only ever considers questions of law. They don't have any jurisdiction over factual adjudications, except in very, very weird circumstances, like lawsuits between the states over where their borders are, things like that, which do happen from time to time.
And that's actually true of pretty much all appellate decisions. All appellate decisions, for the most part, are reviewing questions
almost
of law. law.
All questions of law, yeah.
There are certain cases where they review questions of fact, what's called de novo review, but those are rare. It's usually the case that you're reviewing these questions of law, because what we're really saying is, even if everybody agrees as to what happened, we don't know how to resolve this at the lower court level, because you're telling us conflicting things. And that's what it is in this case, is the court looking at it and saying, we don't have our appellate court telling us what the outcome of this is. We have the Second Circuit saying you can't get damages beyond 3 years. We have other courts that really said you can or hadn't spoken to it at all. We don't know what the outcome is. So the 11th Circuit looks at it and says, well, we think you can get them longer than 3 years. Now you have two courts of equal level saying in this part of the country, yes, you can. In this part of the country, no, you can't. And so that's the Supreme Court coming in and saying, look, we have these two courts that disagree.
It should work the same way everywhere.
It should work the same way everywhere, which is actually the correct way to do it. And those are cases that, quite frankly, the vast majority of cases the Supreme Court decides.
One of the easiest ways to get in front of the Supreme Court.
But a large percentage of the cases the Supreme Court looks at are those questions, because we have two different courts who can't agree how to interpret this. What's the purpose of the court? To resolve disputes. We have two courts in a dispute. So we stick the Supreme Court on top and say resolve the dispute.
So this is also where it gets wonky. The question that Warner sent to the Supreme Court to answer is, basically, does the discovery rule apply? And if so, how does it work? However, and this is another procedural point, they did not actually preserve the question of whether the discovery rule should apply or not. It was not on appeal. They just kind of assumed that it does and asked how it works. They tried to squeeze it in at the Supreme Court, and the court accepted the case to review, but took that first part out and said, we're going to assume the discovery rule applies, and then we're going to tell you, if it does apply, how it works. Yep. And that's important. So, because if you assume it applies, well, then the answer is pretty straightforward. Then yes, you can go further back. And if you read the opinion, Ms. Justice Kagan wrote the majority. She was joined by 5 other justices, so it's a 6-3 majority. There's virtually no analysis of the copyright statute. She just kind of quotes it and says, here's what it says. The statute of limitations doesn't say, oh, and by the way, damages are limited to claims made, or to claims or infringing acts that occurred during the limitations period. It's only limited to claims that are properly before the court. And if you go to the remedial provisions, it doesn't say anything there either. So there's nothing in the text of the act to say you can't go back further if you can somehow find a way to get infringing acts that happened before the limitations period to be timely filed. That's the trick, and it's not easy to do.
Yeah, and again, I think the key to it is that the court, the suit in this case and the discussions around sort of the things with this is we're assuming the discovery rule is in place, because what we're really trying to figure out is there a separate damages rule in the copyright statute? And basically what the court says is no. So basically we apply the standard rule, which is if you can correctly bring the suit over the assertion, you can get damages for how you've been wrong. That's kind of the default. That's kind of the standard, what's to be expected. We're great. That makes perfect sense. Everything around this makes perfect sense. That's what it is. And I think that's why the court's decision here is so short.
It is weirdly short.
It's like 3 pages. I mean, and basically the decision behind it is, hey, given the fact that we say under the discovery rule, under what's been determined in here, the parties agreed that the cert was these were timely rules. He could bring the thing again. Everybody's agreed to the facts, which was he found out about it in 2016 and 2018. It's true. For the purposes of this appeal, he filed. For the purposes of his appeal, we agree with those things. That is the case. Therefore, he filed within 3 years. If he filed in 3 years upon an action which occurred in 2008, because he only discovered it in 2016.
Nothing in the act says you can't get damages for that. The claim is timely asserted, so we're all good. Justice Kagan did take pains to emphasize repeatedly that the Supreme Court has never ruled on whether the discovery rule is proper or not, and they're not going to do it here either, because the issue is not properly in front of the court under appellate procedure.
And that is a really important point in this, and this is the thing we love to talk about on this podcast, about the media not really getting the nuance of cases and understanding it. One of the things you really see in sort of the nuance of this case is the court going to pains to point out we are not determining whether or not the discovery rule is in place.
We're not saying it's correct. We're not saying it's incorrect. We're just saying, based on the record in front of us, we have to assume it was properly applied. And if that's the case, then this is how the law works.
Yeah. And again, what they have in front of them is a question of how does the law work if we all agree upon the facts. The facts everybody agreed upon is the discovery rule is allowed. So therefore, the question is, how do damages apply when the discovery rule is allowed? That's sort of that comment in the beginning. Warner Chappell kind of tried to raise as this went up to the Supreme Court.
It was the bulk of their argument on appeal, which Kagan also noted. She's like, you guys didn't appeal on that issue, but that was your entire argument. But I don't blame them. They didn't really have a good argument that the statute says otherwise.
Yeah. And so they're kind of coming back and saying, hey, look, you didn't argue the discovery rule doesn't apply, so we can't say it doesn't. What you argued was, if it applies, what are the damages provisions? And they said, well, if it applies, this is the damages provisions. We think it's pretty clear. And again, I think a lot of people looking at it would agree that, yeah, that does seem pretty clear, from what it is on the fact. But the key aspect of it that I'd say a lot of the commentary missed in the popular press is how much the court went out of its way to point out the fact that this was the limited question in front of them.
It's almost like they're saying we're answering a hypothetical that we're not admitting is actually valid.
Yeah. And which
is what Justice Gorsuch said in the dissent.
And that we get into the dissent.
The dissent is way more interesting here, and I see a lot of commentary along the lines of the dissent is Gorsuch, Alito, and Thomas. They are not what I would call three of the more popular Supreme Court judges amongst the general population. But this is IP law, and Kirk and I often say IP law cases are interesting because they're not really political. So you get to kind of see just how the judges look at things ideologically from a legal jurisprudence point of view, where there's no political stakes involved. So whatever preconceptions you have about Thomas, Alito, and Gorsuch, you can set them aside. Gorsuch's dissent, interestingly, was not much of a dissent. He didn't really say that he thought Kagan got it wrong. He just said, why don't we just say whether the discovery rule applies or not? I don't care if Chappell or Warner Chappell preserved it. Let's just say whether we think it's there and deal with this now. Or if we're not going to do that, let's dismiss this case as improvidently granted and wait until we get those facts in front of us because, and I love this quote, he says, first of all, he clearly thinks the discovery rule should
not apply.
He says like 4 times, he says it should not be here. But he has a great quote where he says something like, why don't we wait for a case where we can answer a question that matters instead of one that probably doesn't?
Yeah, and I think the real key behind this is you have the majority going to pains to point out the fact that this question is not in front of us. We are given a hypothetical situation and we're asked to respond to, given the hypothetical situation, what's the outcome, which they do. Gorsuch's dissent is basically, the hypothetical is dumb because it's never going to happen.
Yeah.
So why are we trying to resolve it? Why don't we just say the hypothetical is never going to happen because that's not what the law allows in the first place? And who cares whether or not it's been appealed? The interesting thing about it is sort of twofold.
The court can do that, right? It generally does not, but there's nothing that says the Supreme Court cannot rule on an issue of law whether or not it's preserved.
Yeah,
it's unusual.
Every court has the right to evaluate an issue of law.
It's called sua sponte. They can bring it up on their own accord whether or not the parties appealed it. And then sometimes they do, sometimes they don't. I would say it's unusual.
It's very unusual, particularly the Supreme Court. I'd say it's very unusual.
Yeah, but this is Gorsuch saying, I think clearly signaling to the world, we already know how this is going to come down once we get the discovery rule in front of us, or at least how he thinks it's going to come down.
Or at least for the 3 people who are signing on to this dissent.
So he thinks, why don't we just skip right to that part?
Yeah, and I think that it's a good statement behind that. I mean, the one thing I like about it, and Ben said this repeatedly about this case that I love, is this is arguably the first time we have an opinion and a dissent, and everybody's correct.
Yeah, Gorsuch saying this should not be the rule, and Kagan saying, but if it is, this is how it works. Both can be true at the same time. It's kind of a weird situation.
And so, it's a weird scenario is what it is. And again, that nuance, I think, is what's being missed in a lot of the basic press reporting of this, where they're like, oh, what it says is you can take damages back to forever. Well, yes, if the discovery rule is valid. Yeah. Which the other half of the court said we're not too sure.
I would say more than that. They said we're quite sure it's not.
Yeah. And so, and again, what the reason this is kind of a fun case to talk about with this, remember we started this whole premise where I said if we all agree that the facts are correct, we can send these cases up to appeal. This is the Supreme Court dissent saying we didn't all agree the facts are correct.
Well, that's what makes it interesting too, right? Like the underlying facts aren't decided. That may be motivating Gorsuch to some extent to be like, we got this interlocutory appeal. We don't even know if this is really properly in front of us. I mean, for all we know, Neely knew, and this is all untimely and all moot. And so there's a lot of sort of thinly veiled irritation in Gorsuch's dissent. He's polite about it. In fact, he even says, like, I understand why the majority doesn't want to take this up. It's not illegitimate to do that, but there's kind of a come on guys tone to it. Like, we know how this is going to go. And Kagan's opinion too, the number of times that she comes out and says, just to be clear, we're not ruling on the discovery rule. And so what's interesting also related to this is there is already another case pending before the Supreme Court.
Well, looking for cert.
Yeah. Somebody has filed a petition for cert, meaning a petition for the Supreme Court to hear the case. And the question on appeal is, should we have the discovery rule in copyright cases?
Yeah. And so there has to be the evaluation of, is that why they're doing this as to what it is?
Because you only need 4 justices to agree to take cert, and we've got 3 who've already said, we're taking it.
Yeah, I mean, it's pretty bluntly obvious the 3 judges in the dissent are going to vote for cert for this new case, this additional case that's coming down. All you need is 1 judge from the majority to say, yep, we need to actually look at this. And what's interesting is Kagan going out of her way to point out the fact that this has not been considered, to say you got to wonder if somebody's thinking that they're the 4th vote.
You should also note the majority here. So you've got Kagan. She was appointed by President Obama, right?
I think that's right, yeah.
Sotomayor, also President Obama. Chief Justice Roberts, President Bush. Who else is in there? Jackson, appointed by Biden. Barrett, appointed by President Trump. And who's left? Kavanaugh, also a Trump appointee. So there's no rhyme or reason to any of this, right? They're all over the map.
Yeah. Yeah. And so, and again, sort of the comments of the idea that IP law tends to show how people really think. What I think is interesting about this, quite frankly, is from a legal point of view, what we really see here is the Supreme Court taking an issue which has really got very little political implication, I think.
No. This is, as you can tell from us talking about this is a really, really narrow, minor, nuanced kind of issue. And this ruling basically just changes the Second Circuit. Everybody else who's ruled on this was already doing what they said.
Or hadn't
decided yet what they were going to do.
Needed to do. But what you really see behind it is you sort of have all these judges, and you have the 6 justices going to pains to stick with what is the question before us, because this is all we took it up on. And you have 3 judges kind of looking at it and saying, come on, guys, wink, wink, nudge, nudge. We all know what the real question is here. That may be more interesting in many respects than the actual whole thing.
Yeah, and one of the reasons we wanted to talk about this is one, to correct any misconceptions about, like I said, your GeoCities page from 1994 all of a sudden be subject to a lawsuit. I think there's, we don't know, because the exact nuances of how the discovery rule plays out, so long as we have it, that may be short-lived. They may overrule it in the next term. So we may have this exact same podcast again this time next year. I think that's the real thing to keep in mind about this is this doesn't change anything as to what it is. It just says, here's how the damages are supposed to be calculated in the event the discovery rule is used. You don't have the facts of this case having been determined. We don't know what the facts of this case are going to say about how the discovery rule works. Can he actually say he's inside his 3 years in 2016, or is it really 2008? This is untimely. Warner Chappelle wins on that ground. This is over. And it never does go to the Supreme Court for that ground, which is also potentially part of the reason the majority did take this question, is to look at it and basically say, if Warner Chappelle won at the lower court level, because under the discovery rule, we wouldn't have this holding. The court saying, well, under the discovery rule, it should be this holding. And you even have the dissent saying, well, the discovery rule doesn't exist. Well, if you win under the discovery rule, you're also not challenging whether or not the discovery rule exists. And there's an argument that even with the discovery rule in place, that in a typical copyright infringement circumstance, there's a decent argument that it doesn't really work any differently than the injury rule, because copyright by its nature is copyright infringement, I should say, by its nature is normally a publicly facing act, because most of the copyright rights require you to do something in public. You've got public distribution, public performance, public display, public broadcast. So those things are, the standard is that you discovered it, or with due diligence should have discovered it. Well, if it's taking place in public, how can you with due diligence not discover it, right? You probably would under most circumstances. So that's probably going to swallow a lot of these cases. And then in the situations where the violations are private activity, like making copies is prohibited, whether or not you do anything with them. Really making copies is prohibited. But I was telling Kirk before we sat down to record, if I burn 400 copies of Star Wars and stick them in my basement and nobody ever finds out, what are the damages? There's no damages to sue for, so who cares when they happen?
It's not even going to be so it's not even going to be discovered, for one, because you're hiding in your basement. Arguably, you're concealing in your basement because of fraud. But in the event that you make those 400 copies and 3 years later decide to destroy them, what are the damages?
Yeah, there's no damages at all. And if I decide to distribute them 10 years later, okay, well, that's a new infringement. So that's now public and actionable.
So it is kind of this. And again, I think the couple things to keep in mind that are interesting about the opinion, the majority does go to a bit of pains to say the Second Circuit's interpretation is wrong, because it does kind of conflate discovery to injury.
That's the one part of the majority that's maybe a little confusing and could be problematic, is that The discovery rule and the entry rule will probably merge and work the same way in a lot of circumstances. The Petrella case we talked about, it kind of the court even said in that case, it doesn't really matter which rule applies here. These are the facts, and this is how it's going to work in this case. So those two rules are probably going to operate the same way functionally in a lot of typical copyright infringement cases. But then Justice Kagan said that the Second Circuit's reformulation made them work the same way, and that's not correct, which is a little strange, because they're both kind of judicial fabrications anyway. So it's kind of an odd bit of unnecessary verbiage. We'd call that dicta, not necessary to the judgment.
And quite frankly, the dissent has a little bit of sort of the same kind of stuff. They get into a little bit of sort of these side potential side issues around it, where they're saying, hey, if the discovery rule shouldn't really exist at all, but they're kind of and they're saying kind of in this case, we don't really think it applies anyway.
Nor should it apply in most cases,
in any case,
absent fraud or concealment, but that can be dealt with through equitable tolling. You don't need this rule.
Well, but then they also put in the idea, but absent fraud or concealment, equitable tolling. So they also kind of hint us, okay, maybe there is a way it could potentially be done as a door open for this. And again, part of the reason I have to wonder why they're, as a standing position of what are they saying? Why did they take this case? Sort of stuff like that is part of that, because they're looking at this and saying there are like 4 or 5 intermeshed issues here, with any one of which could have prevented this case from ever getting to us in the first place. And since you did send it up to us on one of the 4 issues, let's truly look at that one, which is what the majority says. The dissent kind of looking at it and saying, well, that really is kind of a dumb one to look at, because we really should be looking at this other one, which really resolves all 4. But the idea of them each looking at it and saying, all 4 of these are going to get resolved together, and they may get resolved together by the decision on any one of them, so maybe we should be looking at them individually, and we should be worrying about it. So you kind of get them agreeing, I think, in many respects. It's just sort of what's the important aspect.
It's a very, very strange, unusual case. We don't usually see situations where the majority and the dissent can both be correct at the same time. But I think a lot of the commentary I've seen from knowledgeable copyright attorneys, general expectation is that this other case involving Hearst newspapers challenging the discovery rule, I think we expect the Supreme Court is very likely to grant cert in that case. Now, what they ultimately do, who knows? But we've already got 3 justices who's very clearly gone on the record as saying they know what they're going to do. And so
now that can change. They can change their minds based on the facts.
Definitely can change. They're not beholden to that. But I think this issue of the discovery rule is going to get resolved, I think, one way or the other, sometime in the next year. If they're doing cert now, then that case will be argued and decided in next year's term.
We talked about it, we get people who tell us and in comments they like us when we kind of do these deep dives into like esoteric areas of the law. We figured this was a great one. It's very procedural. It covers a lot of procedural issues. It pretty much is a procedural issue, which is because it's a question of law. A lot of them are procedural issues. If you just read the headlines of how this is being reported in the press, a lot of times that headline doesn't really say what it is, and definitely doesn't get into this nuance of, hey, yes, they may have agreed damages go on forever, and they may have also agreed that only in this limited case, which we're about to say never happens.
And this is probably one final point to make. When you go to law school, professors will often emphasize that a lot of the critical parts of understanding the law is understanding the procedural posture of cases when rulings are made, because where cases are in their overall lifespan can affect what the impact of the decision actually is. And related to that is the standard of review that courts apply when looking at things, because courts don't always have discretion to just throw something out on a whim. Now, the Supreme Court, that's not always the case. So this is a good example of how we have all these weird underlying unusual facts that we're forced to assume are true. They may not actually prove to be true, but we're stuck with them. So this is a very law school-like example. Given this weird fact pattern, it's probably going to never come up. What happens? Okay, well, weird facts make weird law. How about that?
And the reason I particularly like this case is because the court makes very clear the majority and the dissent are answering different questions. And that's why the majority opinion is the majority and the dissent is the dissent in some respects.
Yep. All right, that's all for this time. We'll see you next time. Lauren, play us out.
The views expressed by the participants of this program are their own and do not represent the views of, nor are they endorsed by Lewis Rice LLC, its officers, directors, employees, agents, representatives, shareholders, and subsidiaries. None of the content should be considered legal advice. As always, consult a lawyer. This podcast was produced and recorded in St. Louis, Missouri.